UNHCR's mandate is to seek to assure that asylum space is maintained. In some countries, the only opportunity to address admissibility concerns for individuals arriving without a legal right of access to territory is to claim asylum. The lack of an alternative process results in claims that are then labeled bogus or abusive. This threatens asylum space. Frequently, it is not the asylum system which is flawed. Where this provides a methodology of processing asylum seekers through full and fair procedures to assess their protection need. Rather, it is the migration system, or lack of it, which may be flawed, where it does not address large numbers of individuals arriving at borders seeking access. I suggest that the problem is not necessarily over-generous asylum systems, but possibly underperforming migration systems, which address neither the needs of states nor of migrants. Provision of alternative channels that are effective in meeting these needs is more likely to be effective as a solution. Here we get to the crux of the matter. Why should states seek to respond to the needs of non-refugees seeking access to their territory? First, because states such as Canada are committed, and seriously so, to refugee protection. And at the core of this commitment, as demonstrated through accession and ratification of relevant international law, is the implementation of obligations such as those contained in the Refugee Convention, Article 31. In pertinent, this part states that the contracting states shall not impose penalties on account of their illegal entry or presence on refugees who enter or are present in their territory without authorization. Refugees need protection. Refugees need protection-focused solutions. If the mounting tide of non-refugees who seek to take advantage of this provision by submitting unfounded claims for asylum is not addressed, access to territory for refugees in desperate need of it may collapse under the weight of processing backlogs and negative public outcry. Thus, to preserve asylum, states must effectively address migration. There is another vexing concern. Some authorities may be uncomfortable with the loss of sovereign control inherent in Convention Article 31. In the tension between individual human rights and the prerogative of states, there is a threat that the former may be subsumed. The Convention limits the exercise of sovereignty, expecting that asylum seekers arriving spontaneously be accorded protection as refugees if they meet objective criteria. On the other hand, resettlement of refugees from countries of first asylum elsewhere is an entirely voluntary act of goodwill of states, not required by the Convention and not governed by any requirements beyond what the authorities of a country choose to impose domestically upon themselves. Sovereignty is retained and control exercised over who can come, where they can come to, and how they can come. Increasingly, UNHCR hears states seeking to prioritize real refugees to be brought from camps elsewhere as opposed to those stigmatized as abusive due to their taking matters into their own hands and moving without official sanction, otherwise referred to as irregular or secondary movements. UNHCR very much appreciates the humanitarian actions of states who resettle refugees, particularly as this is a very strong demonstration of commitment to protection and to international burden sharing that frequently serves the needy and vulnerable, in which Canada plays a major role. Such action complements states' granting of asylum to those who seek it of them, but it cannot replace the obligation to protect those who arrive in a state's frontiers. Second, because northern countries cannot hope to address mixed flows through restrictive enforcement mechanisms alone. Freedom of movement is a human right and one that is regularly exercised. Economic migrants have a significant motivation to utilize all means at their disposal to access attractive labor markets and other incentives to enter wealthier countries. And they are tenacious and creative enough to bypass the most extensive and expensive border control mechanisms operating in the world today. Economic migrants who are interdicted at borders are unlikely to cease their efforts due to marginally lesser access. They simply keep trying until they are successful and increasingly take advantage of tools made available to them to increase their chances of success. The frequent outcome of more restrictive state practice is more pervasive illicit movement and often more criminal activity in the form of trafficking and smuggling. Further, as those seeking entry turn to criminals whose activities often offer greater chances of success regarding access to countries and their labor markets, economic migration is further complicated by exposure to drug trafficking, trafficking of women and children, and other cross-border criminality. In an age where the threat of terrorism is a constant concern for national authorities, this focus on control is magnified and prioritized as well. As I mentioned earlier, with regard to access to territory for asylum seekers, systemic collapse is the likely outcome, where states that build huge enforcement capacities cannot cope to keep pace with migration trends that are global in origin and reach. Incapacity to limit some types of movement is obvious in most systems, where even at the earlier stage of their implementation, a need is recognized to prioritize interdiction targets. With limited resources to address seemingly unlimited access, enforcement entities tend to focus on key elements of illicit cross-border movements such as security threats and drug traffickers. Third, since some states actually seek to attract labor migration, states are sovereign and by right control their national territory. However,